much, Anupriya, for such a detailed discussion about my work. And I would also like to thank the organizer, particularly Dr. Yadav, Dr. Tapan Chandola, Dr. Rajiv Kumar Singh, and entire organizing team for this constitutional law lecture. Though the topic which is given to me, formal equality to substantive equality under the Constitution of India, the topic which is assigned is too wide, that how much I may justify with the topic in the given time is going to be a very, very difficult task for me. However, I have divided my lecture in 4 parts. In first part, I'll be introducing the theme and will discuss the historical background and development of equality right in India. Then in part 2, I will discuss the provisions of right to equality in our constitution. And thirdly, I will discuss the formal equality and substantive equality with case laws with reference to reasonable classification doctrine, the positive action, affirmative discrimination or affirmative action. And now we are reaching to indirect discrimination or hostile discrimination. Many things are there. And then finally, I will conclude this topic. So in the list of human rights, in the list of rights as a whole, because there are many types of the rights, human rights, natural rights, fundamental rights, legal rights, civil rights, so many types of the rights. So if you see the list of the rights, then particularly in fundamental rights, the right to equality is bound to be recognized as a very important right. In fact, the very demand of the fundamental rights, you see, arose mainly as a protest against the political and social inequalities and the concept of privilege, because some of the persons in the society, they were facing the political and social inequalities. However, the other persons, they were also enjoying some of the privileges. So in order to bridge this gap of equality with that inequality, this demand for the right to equality arose as a fundamental right in many countries. It's not confined to India, but in many countries you will find it. And the influence of the American and the French Revolution in the evolution of this doctrine of fundamental rights, that needs no special mention, I think, because these revolutions were to a great extent revolts against the inequalities and privileges, as I told you. In France, it was the protest against the privileged class of nobles and clergymen. In America, against the privileged this Englishmen. Then the opening words of Rousseau in his Contract Social, if you see, that man is born free and he is everywhere in chains. So this signature tune of American Declaration of Independence, that all men are created equal, but they are not being provided equal rights, they are not free, though they have born free. So this agenda of equality and this signature tune of the equality, that started from the American Declaration of Independence, that all men are created equal. And also in French, a declaration that men are born free and that men are born and always continue to be free and equal in respect of their rights. So that was also one of the demand in the French declaration also regarding the equal rights of the person concerned. And you see these words of the French declaration and the American Declaration of Independence, they are also we find in the constitution of our country, because the constitutional authors or the makers of the Constitution of India, they inserted equality in our supreme law of the land, because equality is regarded as the basis of democracy. We have opted for the democracy, ours is the largest democracy. So in that democracy, equality is considered to be the base. And this concept of equality is also very closely associated with the theory of natural rights. And the beginning of the principle of equality may be traced from the theory of the natural equality also, because it was laid by, in the American Constitution, you'll find by Thomas Jefferson, that all men are born equal, and it is the man himself who creates differences between individuals. So that creation of differences, that brings inequality. And that inequality has to be abolished. And that is why, because all men are equal, they should be treated equally. And if they are not being treated equally, then this basis of democracy would not survive. So equality implies the treatment and opportunities of all persons alike. That is, who are in the same category, who are in the same class, they must be treated alike. So equality also presumes that there must not be any discrimination when it comes to the opportunities, because until and unless you are having the opportunity to have something, then equality cannot be accepted. Therefore, right to equality is essential for all individuals. For what? For their development. And in India, you see the demand for this right to equality that began right from late 19th century. And the first Constitution of India bill, that was of 1895, that was prepared by the Indian National Congress. After the establishment of this Indian National Congress in 1885, just 10 years after, they have also prepared a Constitution of India bill. And that was guaranteeing to everyone the equality before the law. And after that Constitution of India bill, that there was another thing, that was Home Rule Bill by Annie Besant. So she also described about the equality, that law should be equal to all. And these were the demands which started in India to get the equality as a right, as a fundamental right to all the individuals. Because that was the time that India was in the slavery of the Britishers, and there was a category of the privileged class and non-privileged class. So to avoid that inequality, to avoid or to bring the equality, these demands were there so as to bring the equality before law, or the equality to all the persons. Then the Government of India Act 1915 for the very first time put some of the provisions. I cannot say that it is total equality which they have brought for the Indians at that time, but a little bit you can see in their section 96 of the Government of India Act 1915, which particularly provided for no disability from holding any office under the crown. That is by reason of any religion or place of birth or descent, color, or any of that. So you see that a little bit has been started to be given from this Government of India Act 1915, but it was not a complete equality, because it was confined only to some of the offices under the crown at that time. Then between 1917 to 1919, many of the resolutions were also produced. And yes, somebody is raising hand. So you see that many demands were made by the Congress at that time, that this right to equality and right to free speech, these two should be given to all the persons. And then the Commonwealth of India will also prescribe for the equality before law and equality of all the sexes, that there shall not be any discrimination between men and women. Motilal Nehru Committee of 1928 report, that was also demanding and recommending the equality of all the citizens, and no discrimination on the basis of sex, no discrimination between men and women, as the citizens should be there. And then the Indian Statutory Commission, that is known as Simon Commission, that also recommended in its report of 1930. Because these demands were continuously being made by the Indian National Congress by various bills which have been prepared. And the report of Motilal Nehru Committee also, they all were demanding and claiming the equality rights. So in 1930, when the Simon Commission came at that time, it started saying that why the equality should not be given to the Indians at that time. Because basically, if you see that what that report of that commission says, that the abstract declarations of any such rights are useless, because until and unless you are having the authority to execute those rights, to make them those rights effective, then those rights would be of no use. So if abstract declaration are not to be there in that constitution or in the act which were being governing at that time the Indians, so that claim or that demand of the equality right was not sustained. And you see, the Government of India Act 1935 again put some similar provision as have been given in 1915 Government of India Act, section 275 and section 298 of this Government of India Act provided again for a limited area, that is of the public offices, government offices under the crown at that time, that the person cannot be qualified, or that person should not be disqualified on the ground of sex for holding some of the offices, or he should not be subject to any disability by any reason that is related to his race, that is related to his religion, or some similar grounds. So if we find that initially before the Constitution of India came into existence in 1950, this was the historical background or development of the equality rights, though directly there was no equality which is given to the individual. However, some relief was given by the Government of India Act 1915 and Government of India Act 1935. So when the Constitution came into, we see that Constitution is the end product of the struggle of independence against the British rule. It was also a struggle for the replacement of an unequal social order in India. So one of the preambular objectives of the Indian Constitution is its promise of equality, and equality of opportunity and equality of status. So equality as a value is recognized as a core pillar of the Constitution of India. The directive principles of the state policy, also enshrined in our Constitution, makes a clear mandate to achieve the equality and social justice. Equality along with liberty are the words of passion and power. You find these words in the French Revolution as their watchwords. So US Congress gave them practical effect in their 14th Amendment by providing the equal protection of the laws. Besides that, not only the US Constitution, but Universal Declaration of Human Rights 1948 also provided for this equality rights. Particularly if you see Article 7 of the UDHR, then it also declares that all are equal before the law and they are entitled without any discrimination to the equal protection of laws. So these two phrases are also the part of the Universal Declaration of Human Rights. Equality is a human right also. Equality before law and equal protection of laws. While you see the 14th Amendment of the US Constitution only provides for the equal protection of the law. So the makers of the Indian Constitution were conscious of this history. And constitutional advisor B.N. Rao, Dr. Ambedkar, K.M. Munshi, and Alladi Krishnaswamy Iyer, they prepared a draft on the various demands regarding equality, because they were also forming the subcommittee on fundamental rights. So they prepared this draft and they have submitted this draft to the subcommittee of the fundamental rights, and two drafts, Dr. Ambedkar and K.M. Munshi's draft, those were guaranteeing the equality before law and equal protection of laws. They were considered, and the draft Article 15, that was containing two parts, two important parts. You see, first part was relating to the right to life and personal liberty, and second part was related to the equality. So this Article 15, which was the draft article that was being debated and discussed in the Constituent Assembly. And the main focus was only and only towards the first part of this article, draft Article 15, that is life and liberty, which is Article 21 of the present Constitution. And the draft articles 9 to 12, those were being discussed because these are corresponding to our present constitution, article 15 to 18. So what we are having today as article 14, that is equality, that was article 15 of the draft constitution, and that was the second part of the article 15, while first part was only relating to the right to life and personal liberty. That was mainly being discussed, not the second part, in such a manner as it should be. However, because equality was being demanded from the earlier time and in the constitution also, not only the equality and liberty, but that was also being made, as I told you, the preambular objectives also. So equality clause in the constitution guarantees a right to equality. That was also put as a fundamental right, because at the revision stage, this second part of draft article 15 was renumbered as article 14 of the constitution, which was said to be very, very important. And by and large, we can see that the same concept of equality in article 14 of our Indian constitution, as we have seen in the Universal Declaration of Human Rights or in the 14th Amendment of the US Constitution. So Article 14 rules out all kinds of discrimination, but it supports positive discrimination. Now, this is the area from where we can have the idea of formal and substantive equality, particularly to give effect rather than practical effect to the equality, because what is positive discrimination is just to give effect to a practical equality, a real equality. That is the substantive equality. I'll be discussing in detail on that also, but this is the initial point where from we can catch the formal equality and the substantive equality. Further, in order to bring that practical effect to the equality, Article 17 was made a fundamental right which abolishes untouchability. That is what I'm saying, that the social and political inequalities were there in the society. So how to bring the equality? So first of all, it is required that the inequality which is in existence, that has to be abolished first. So in order to bring that real equality, first thing which was done in the constitution is that Article 17, which makes the untouchability as an offense, and that has been abolished. And that was an evil practice which was carried out by the members of the lowest rung of the society. They were prevented from entering a place of worship. They were prevented from taking the water from the tank or from the well, where from the other public persons they were taking the water. And Parliament is also tries to make the laws prescribing punishment for the same. And now this practice of untouchability is an offense, we all know, and anyone doing so is punishable by law. The Untouchability Offence Act, the renamed as Protection of the Civil Rights Act, and presently the SC/ST Atrocities Act. These are all providing for the penalties. So this article is leveled more against the private conduct than against the conduct of the state, because we all know that the violation of the fundamental rights, the remedy is available against the state, but this is the right which is available against the private individual also, because the equality is to be sought against the individual also. Because the individual is being faced with the inequality. So where from he can ask for the equality rights from the private individuals also. And that's why you see the first aspect of practical equality was through this provision of Article 17 of the Constitution. Then as a theoretical effect is given to this equality by Article 18 also. That's also a fundamental right which abolishes the titles, and it doesn't abolish the military and academic distinctions, because that is being secured by the person by his or her use of these skills, by her or his labor in that particular area, and that's why these are not abolished. But the titles which were being given during the British rule in India, titles such as the Lord, Lady, Rai Sahab, Rai Bahadur, and so many other titles, those were being used. But this has been done away with the Constitution of India to bring equality. Now, coming again to Article 14 of the Constitution, that provides that the state shall not deny any person equality before the law and equal protection of the laws within the territory of India. So two phrases have been used: equality before the law and equal protection of the laws. So the word law in the first phrase, that is equality before the law, that is used in a very, very generic sense, while the use of the word laws in the second phrase, that is very specific laws, particular law which has been enacted by the competent legislature, then it is related to that law. So equal protection of laws means that law should not be enacted so as to bring inequality, so as to discriminate the other person. That is how this law word in the second phrase is used in the specific manner, or it is not in generic sense. And then we find that this entire equality jurisprudence is a group of 5 articles. 5 articles, that is Article 14 to 18 in the Constitution of India. And it is also known as the Equality Clause, because in many of the judgments of the Supreme Court, you'll find that they have used this term Equality Clause. So equality before the law is the first limb of Article 14, and that guarantees to every person in a very, very broad term the equality, and the courts which are administering the justice, they will not consider the position or the status, the background, the character, or anything which is related to the person concerned who are appearing as the parties while deciding a case law. Or as Dr. H.M. Seervai also writes that law is not the respecter of the persons. So it simply means that howsoever high a person may be, but law is above all. So this first limb, that is equality before law, is also known as a negative concept, which is similar to the rule of law concept of Dicey. Dicey, that is he writes about the rule of law and its aspect, the supremacy and the equality before law, and it is a declaration of equality of persons, which is taken particularly from the English common law in England. So this first aspect, or the first limb, that is equality before law, that means that every person is equal before the law, that every person is not to be judged on the basis of his or her position in the society. What is the status of that person? The law cannot change according to the status of the person concerned. Law cannot be changed according to the background of the person while deciding the case, while deciding the any law in favor of that person concerned. So the basic point for this equality before law is that the law is not respecting any person according to his or her status or position in the society, but law will treat every person equally. This is what equality before law means. Then the second limb of Article 14, that is equal protection of the laws. This has been taken, as I told you, from the 14th Amendment of the US Constitution, and it is very positive in nature also. This limb particularly requires some specific action from the state. As we know that India is a country which is plural in nature, and everyone cannot be equal. They are not equal, they cannot be equal. They differ in their language, they differ in culture, geographical surroundings, on the basis of age, gender, their dresses, the region, religion, caste, many more grounds may be there in which they may differ from one to the other person. So the phrase that confers a right for equal protection of the laws, and that cannot mean the protection of same laws for all. And this is how we find the evolution of the doctrine of reasonable classification also. Reasonable classification doctrine is a device which has been evolved by the judiciary in order to give the equal treatment to all the persons who are different by virtue of their birth in a particular caste or category or creed or race, by virtue of their language, their culture, their age, their region, religion, many things may be there. So how to treat them equally, because they are not equal, they are unequal on different grounds. So single law, if it is to be made applicable to all those persons who are really different by virtue of different grounds, so how to give the equality, how to make them, how to bring the equality for those persons. And that is why you see that this doctrine of reasonable classification was evolved. And this reasonable classification simply means that Article 14 forbids discrimination and class legislation, but it does not forbids the reasonable classification. Now, this reasonable classification test is laid down by Justice S.R. Das in a state of West Bengal versus Anwar Ali Sarkar case. It was somewhere in 1952. And this reasonable classification doctrine is still being followed by the Supreme Court in many of the cases. There are so many cases. I think I don't have the time to discuss all those cases. Ajay Wahi case, N.S. Ratinam case, Lakshmi Khansari case, many more cases where you will find that this doctrine of reasonable classification has been followed by the Supreme Court. So now the question is, what exactly this doctrine is, this reasonable classification. So this doctrine has two aspects or two test doctrine. The first is that the classification must be based on intelligible differentia, must be based on the reasonable differentia, which distinguishes, because differentia word means what? It is bound to distinguish, it is bound to distinct, it is bound to make a separation. Separation of what? Distinguishing the persons from one group to that of the other groups. So classification must be based on an intelligible differentia, which distinguishes persons or the things that are grouped with those of the left out of the group. So there are two groups. For one, the law is made, and the other group for whom the law is not made. But the second test of this is that the differentia must have a rational nexus or a rational relationship to the object sought to be achieved by that particular law or act or statute. Now, for an example, to understand this two-type test of S.R. Das in this reasonable classification doctrine. For example, March, now today we have started in the month of March, and everybody who is salaried must be thinking of the income tax. So take the example of the income tax. Now, we all know that there are different slabs of income tax. For example, if the income is below 5 lakhs, then the persons, they will not be responsible for paying income tax. Then there is another slab, 5 to 10 lakhs, 10 to 15 lakhs, 15 to 30 lakhs. So many other slabs are there. For what? For the persons who are coming within that income category, they would be responsible to pay the taxes. This is the law. Now, the reasonable classification is that the groups or the slab has been made, and that slab in which one group may come is considered to be the left out from the other groups. And in that way, you see, that if the person who is having or who is earning or whose income, annual income is 10 lakhs, then he would be responsible to pay the particular percentage of his income as the income tax. Suppose 10% of the income, then 30 up to 30 lakh will be paying 20%, then 30 and above would be paying 30% of the income tax. So here you see that a classification is made between the persons who are belonging or who are coming under the particular income group. They are earning the income up to that limit, up to the other limit, then they have been grouped together. So this is what the classification is made of the persons who are grouped in one and who are grouped in the others. And this is based on the intelligible differentia, because the percentage of the tax is being made higher than the earlier one, that if the person whose salary is only up to 10 lakhs, then he can pay up to 10% of the salary. Who is earning 30 lakhs may pay up to 30% of the salary, and in similar way these things can be done. So this is a reasonable differentia. This is a reasonable difference between the groups who are made together for this 30%, 20% or 10% earning group in the income group for the income tax purposes. Now, the second test, which is important, is that the differentia, that is the groups which have been so made, that must have a rational relationship to the object sought to be achieved by that particular law. Now we have to see the rationale of that relationship. Relationship of what? The income tax is to be paid. The object is to take the tax, and then the statute object to take the tax, that is the object. And the relationship is what? Relationship is rational because it is based on the reasonable differentia, that is up to 10 lakh, up to 20 lakh, 30 lakh or above. This is the reasonable differentia. But suppose instead of putting the income, earning income as the reasonable differentia, for example, 10 lakh, 20 lakh, 30 lakh, if it would be like that, the persons who are having black hair, they would pay 10%. The persons who are having gray hair, they would pay 30% of the income. Can it be considered to be a rational relationship of the object to be achieved? The object is only that the person who is earning higher income would pay a higher amount of tax, and the person who is earning lower income would pay the lower amount of income tax. This is the object. But how this could be held rational if this object is to be achieved not by making the slab of the income, but by the color of the skin of the person, color of the hair of the person, or being decided on the basis of some other grounds which are not rational, intelligible or reasonable. So this is how the income tax slabs are said to be based on this reasonable classification. Similarly, in this reasonable classification, not only the slabs of the income, but other grounds are also being taken, and those are also held to be reasonable. For example, the income tax which are being taken from the senior citizens, that is the persons who have more than 60 years of age, they may have some other benefit in the income tax. So that is again can be said to be a reasonable classification, because the persons who are grouped, they are different from the groups who are left out, because 60 and above, that is related to all the persons. That is not only again to some persons, or that their skin color is different, their hair color is different, but the age is the criteria. So reasonable classification doctrine which was evolved, that was just in order to forbid the that was forbidding the discrimination, that was in order to bring the equal protection of the laws, because everyone is different on the basis of different grounds. So how to treat them equally, this was devised by the Supreme Court, and that's how you see that the differentia, that has to be reasonable, that has to be rational relationship with the object which is sought to be achieved by the statute. If these 2 points are fulfilled, then the law would come under the category of reasonable classification, and it would not be barred by the doctrine of equality, but it would be saved from the doctrine of equality itself. But the second part of that Article 14, That is to say, the equal protection of the laws. And this is one aspect of the substantive equality also. Now, this classification rule gives the content and significance to the right which is guaranteed in the second limb of Article 14, that is equal protection of the laws. And that means that law is equal for those who are similarly situated. And this reminds me also the simplest statement of the principle of equality, that the Aristotelian formula also, that likes should be treated alike. So the second limb is based on that Aristotelian formula, that like should be treated alike, there should be equality of treatment, the person should be protected. That will bring the equality, that will bring the substantive equality, not the formal equality that everyone as it is has to be considered and then bring or then impose any law and then to give any effect of that equality. That is not possible. So this Aristotelian formula that like should be treated alike is related to that substantive equality aspect. It doesn't provide for an absolute equality of treatment to all the persons, disregarding their differences, sex, age, and others. You see, these were some of the examples which are bringing the difference in the society. And some of the cases which have been decided by the Supreme Court are good examples also on this equal protection or equal treatment of the equality to all the persons, whether it be the Devdasan case or John Vallabhatom case, then Javed versus State of Haryana case, Naresh Kumar, many of the cases, they are the examples. Because you see in West Bengal, Anwar Ali Sarkar, the court held that the equal protection of the law is a corollary of the first one. And it is difficult to imagine also that a situation in which there is any violation of the equality before the law without the violation of the equal protection of the laws may be there or not. So these two limbs are only for the purpose of understanding the formal and the substantive equality. While if we see that there is a violation, then the court would say that there is a violation of Article 14. Article 14 comprises both the corollaries, both the parts, that is equality before law and equal protection of law. This was the judgment of the Supreme Court in Ali Anwar Sarkar case also. And this judgment of Ali Anwar Sarkar, you can also see in the later cases, whether it is Kathi Raning Rawat case or special courts will act. So on the basis of different fact situation, the decisions were bound to be different. And here the court have also considered the aspect of the substantive law and the procedural law. And whether it is a procedural law or the substantive law, Article 14 would be applicable. So the area of its application, the jurisdiction of Article 14, that is also expanded in these cases to substantive as well as procedural law. Maneka Gandhi is an example for that also. Then classifications may have been different bases, and it need not be scientifically perfect, or it may not need not be logical. It was also held, you see, in Nagaland Senior Government Employees Association. It was of 2010 judgment that if I am saying that there must be a reasonable classification, then you cannot check that classification on the basis of its niceties, or that there is some mathematical calculation on the basis of which there may be a classification, or there are certain perfect logics on the basis of which there may be a reasonable classification, or there are certain scientific rules, or the classification may be made on that perfection. So it cannot be there, because these are the devices through which the persons will be treated equally. They would be given equal protection, and that's why this has been devised. And that's how you see that even a single person can be a class in himself. And the very important case on the point, if you are reminding the case of Charanjit Lal Chaudhary, 1951 case, that a single company, which is a Sikh company, which was started, and the share cases were there, and the management of that company that was under the government at that time, because that was considered to be coming to a lockdown. So that single company or single individual was made as a class by the application of this doctrine of classification, of reasonable classification. So how the equality, you see, is a dynamic concept. And this is something in which we find that the doctrine of reasonable classification has been evolved by the Supreme Court, and in many of these cases, the doctrine of reasonable classification has been applied. And the court was also coming to the conclusion in many of the cases that a single person may be held a group in himself, or it may be based on the geographical grounds, that if there are certain classification which is based on the basis of the geographical conditions, that can be a valid or reasonable classification. Then it is related to the genders also. Then in matters of the administrative discretion, you see, this doctrine of reasonable classification has been again applied by the court. But when this doctrine of reasonable classification was being applied by the court, then came some of the other cases in the Supreme Court where the judiciary was of the opinion that this doctrine which is laid by the Supreme Court, which is not in the text of the Constitution, that is overpowering the very concept of equality. Because every time the courts are bound to see that whether a particular law is based on the reasonable classification or not, whether there is a rational relationship or rational nexus with the statute which is made on the basis of reasonable classification or not. So this equality is considered to be a dynamic concept, and that's how a new dimension to this equality was given by the Supreme Court. And the court said that Article 14 has a guarantee against arbitrariness in a state action. And this doctrine of classification, which has been evolved only as a subsidiary rule for testing whether a particular state action is arbitrary or not, that is not correct one. And that's how you see a case was decided by the Supreme Court in 1974, E.P. Rayappa case, which you see has started to bring this new dimension to the equality instead of reasonable classification. Though you see that this classification doctrine has never been overruled, it is still valid. But at the same time, this new concept of equality has been brought by the Supreme Court, that is known as the principle of arbitrariness. Then equality is something which is said to be against the arbitrariness, or the arbitrariness is the negation of equality, or equality and arbitrariness are the enemies, they are the sworn enemies. So these type of the observations were given by the Supreme Court, Justice P.N. Bhagwati, Justice Krishna here in E.P. Rayappa case. And to the extent they said that the equality cannot be cribbed, cabined, and confined within the traditional or doctrinal limits. So this traditional and doctrinal limits was what? The doctrine of reasonable classification. That was not in the text of the Constitution. So this doctrine, which was in existence right from 1951, Lakshmi Khansari, then Anwar Ali Sarkar, that continued to be in operation, that continued to be applied by the courts in many of the cases. Even presently, it is being followed by the judiciary. But in between this time, 1974 onwards, this arbitrariness was also inserted as a part of the equality, that if there would be some arbitrary action on the part of the state, if their law would be arbitrary, then this Article 14, that is equality, would be there, and that could be declared as unconstitutional, violating fundamental rights of the person concerned. So this doctrine of arbitrariness that was followed in Maneka Gandhi case, you see, R.K. Dalmia and Justice Tendolkar also laid certain propositions regarding that, but it was an earlier case, but that was also regarding. Then besides R.D. Shetty case, then Air India Nargesh Mirza case was there. Then many more, John Vallamatom case also, many more cases were there where you see that this arbitrariness was also given way, so that if any action of the state is based on arbitrary discretion, that would be declared as unconstitutional under Article 14 of the Constitution. So equality in Article 14 is said to be the genus, while Article 15 to 18 are the special. So Article 14 that was started or that was begun with the two phrases, formal equality and substantive equality. Later on, by devising this doctrine of reasonable classification, more and more substantive equality was tried to be given to the person concerned. Then again, this arbitrariness principle came, though it was severely criticized by H.M. Seervai. That this arbitrariness principle is not a good principle on the basis of which the state action can be decided, which are violating the doctrine or this right to equality. But in order to understand the other aspects of the equality, we have to read the equality clause as a whole. And that equality clause, as I told you, is spread in the 5 articles, that is Article 14 to Article 18. Then Article 15, that is a prohibition of the discrimination on the grounds of religion, race, caste, sex, or place of birth. And subclause 1 of this Article 15 says that the state shall not discriminate against any citizens on any of these grounds. So the 5 grounds are there, and the state shall not discriminate. Now, for the purpose of understanding a state, Article 12 is there, which includes not only the parliament, the state legislature, government of India, or the state governments, but local authorities and other authorities also. So state is given a very wide interpretation in Article 12 of the Constitution, and the entire state which comes under that definition. So for that, this provision is made under Article 15, that the state shall not discriminate against any citizen on the grounds of religion, race, caste, place, and sex, and place of birth. Then it also says clause 2, which is also very important, which says that the state no citizen will be subject to 4 things. One is disability, other is liability, then restriction and condition. So the citizen will not be subject either to any disability or to any liability or to any restriction or condition for what? With regard to the public places. Public places, which includes the restaurant, which includes the shops, which includes the other places where there is no fee or where there is no license to enter into, that is open for public. So that is that, but the use of or to enter into. So these are the 2 things which are secured by Article 15 clause 2 for all the citizens of the country concerned. So there would be no disability, there would be no liability, the person would not be disabled to enter into or to use any of these things, public wells and other things. So on what? On the grounds of what is given under Article 15(1), religion, race, caste, sex, or place of birth. However, when we talk about, this is the general, this is something which is not to discriminate in general terms, that is equality before the law. But when we talk about the equal protection of laws, so how that equal protection would be given to the person concerned, that is, you see Article 15 clause 3 is there. Article 15(3) that was there in the original Constitution, that empowers the state to make the provisions for women and children. So any specific provision, any specific law which is made for the women and children, that is something which is in order to bring the equal protection to those persons, because social and political inequality, social inequality on basis of the sex, on the basis of the gender, so that is tried to be minimized by virtue of this provision, Article 15 clause 3, to bring the substantive equality, and by making the provisions for women and children. So under Article 15 clause 3, you see many of the laws have been made specifically for women and the children, so that they may be brought in the mainstream. So it's not confined, this discrimination was not confined only to the gender or on the basis of the age. Only these are not the marginalized, only they are not the persons who may be put under the category of the vulnerable groups, but the other persons were also being discriminated in the society, for whom the special provisions were also required, so that they may also be meted out with the substantive equality. And that's why you see that when the case was decided by the Supreme Court in Madras versus Champakam Durai Rajan, a different aspect has been given by the Supreme Court, and in order to undo that judgment, the constitution was amended for the first time. And by first amendment to the constitution, 1951, article 15 clause 4 was inserted, and that empowered the state to make special provisions for the advancement of the scheduled caste and scheduled tribes. Because at that time, the conferment or the differentiation or the allotment of the seats on the basis of the Brahmin caste and the other caste, the SC caste, the general caste, so that was there in that order. So how to go about that and how to bring that equality, this 15 clause 4 was inserted for the advancement of the scheduled caste and scheduled tribes. Then again, you see Article 15 was amended twice, more time after this first amendment, one by 93rd Amendment of the Constitution in 2005, whereby Article subclause 5 was inserted to Article 15, which was basically a reservation for socially and educationally backward classes in the state and the state-aided educational institutions. And second amendment or the third amendment, which was inserted by 2019, that is 103 constitutional amendment, which inserted for the economically weaker section of the society for EWS reservation. Though this article 15 clause 5 was also declared as constitutional in Ashok Kumar Thakur case. So you see that article 14 is the genus. However, article 15 to 18 are the species. 17, 18 I have discussed with you, untouchability and abolition of titles. But 15 is important for the purpose of bringing the substantive equality, because it is a guarantee on the basis of which there cannot be any discrimination on the grounds religion, race, caste, sex, place of birth. And how to go about that? By providing under subclauses 3, 4, 5 and 6, so that on that grounds the law can be made, state can take the action, and that would not be considered discriminatory, because this is bringing those persons on the level playing field, so that they may also get the opportunity to be in the mainstream. Similarly, if you see Article 16, that is also one of the species of the right to equality, that also talks about the equality, but that talks about the equality of opportunities, which is there in the preamble to the Constitution of India, that talks about the equality of opportunities in the matters of public employment, the services under the state. Because if you see Article 16, Clause 1, that speaks about the equality of opportunity for all the citizens. That is related to the employment or appointment in the public, in the office under the state. So the term in the matters related to the employment or appointment, that denotes to all the matters in relation to employment, both prior and after the employment, which is incidental to the employment. So that is, you see, from the appointment to the pensioners' benefits also. So everything that is coming in between the promotion and the other things, the seniority matters, many things may be the part of that, and that is saved by Article 16 of the Constitution. That means that all the persons who are situated similarly must be treated in a like manner. This is the crux of the equality of opportunity. It is just not the legal equality, it is also a real equality, so that opportunity may be made available to the person concerned, so that they may got the opportunity, and then they can have this right to equality. Because until and unless the opportunity is being given, then the person cannot reach to there. And that's how this opportunity is allowed or guaranteed by Article 16 of the Constitution. which prohibit discrimination. And then you see Article 16 that assures this equality in public employment, that also prevents the state from making any discrimination on the grounds which are there in 15(1). But at the same time, two more grounds are added in this equality in the matters of public employment, that is you say descent and residence also. Besides the religion, race, caste, sex, place of birth, descent and religion are also added grounds on the basis of which the state cannot make any discrimination. Now, so far as the residence has been made a ground, but again, you will find that Article 16, Clause 3 speaks about that local candidates may also be given preference in certain posts. That is the provision therein. But for that, that has to be declared in advance. It has not to be declared later on. When the advertisement for the post is there, it has to be declared at that time only. So this article provides the autonomy to the state to grant special provisions for the backward class or underrepresented persons, or who are not adequately representing in the public service, in the services under the state. They may be the SCs, they may be the STs who are not there adequately in the services of the state. For them, the article provides the opportunity to have the services of the state. Then provisions for the reservation in promotion, consequential seniority are also granted to the SC/STs who are inadequately represented, and all these you find that was not in the original constitution. They all have been brought in the constitution by various amendments: 77th Amendment, 81st Amendment, 85th Amendment. Provision 335 was also there, that was also amended by 82nd Amendment. So many amendments have been there just in order to give this real equality, just in order to give the practical equality to the persons who are there or who are in the society are not getting, who are the equality, who are said to be unequals in the society. So to avoid that inequality, these type of the provisions have been inserted by the constitutional amendment. These constitutional amendments have been challenged also, but these amendments have been declared as constitutional by the Supreme Court in M. Nagaraj case in 2006, and many other cases were also decided after that, like Salahuddin case in 2011, then Suraj Bhan Meena case of 2011, Suresh Chand Gautam 2016, UP Power Corporation, Rajesh Kumar 2012 case, S. Paneer Selvam case was also there. Then Mahesh Chandra Negi 2017, B.K. Pavitra 2017 and 2019, Jarnail Singh versus Lakshmi Narayan Gupta 2018. So all these cases which were related to the consequential seniority, related to Birpal Singh, Ajit Singh case, many of the cases were there. Wherein the court have discussed on the amendments, and this have been discussed, declared as constitutional also. And you see some of the discussions were made after M. Nagaraj case, particularly in Rajesh Kumar UP Power Corporation case, and Salahuddin and Suraj Bhan Meena case relating to the promotion, reservation in promotion. Then that have been done away in the B.K. Pavitra case, and finally in Jarnail Singh versus Lakshmi Narayan Gupta case. So now what we have is that the persons belonging to the SC/ST categories, the other backward classes of the persons, if they are not adequately representing the services under the state, they would have the opportunity this equality of the opportunity to come in the services of the state in the public employment, and for that they may be given the reservation in the services matters, whether it is related to the promotion, it is related to the consequential seniority, or whatever, they would be given this special benefit. Then you see that besides this, some of the persons who are belonging to some of the specific religion or some of the denomination in a religious denominational group also, then provision is there in 16.5 itself, which was there in the original constitution, that they would not be deemed to be illegal if it is being given. And by 103 amendment, 103rd amendment to the constitution, one more clause has been inserted, that is 16 clause 6, again for the economically weaker section. Though this has been pending before the Court of Law and Youth of Equality versus Union of India since 2019, writ petition is there. The judgment is still awaited. Whether this EWS is going to be constitutional or not, that would be depending on the decision of the Supreme Court. But for the time being, that Article 16 clause 1 and 2 that speaks about the equality of opportunity, and at the same time it also speaks about the discrimination ground would not be there, and the state shall prohibit, a state would be prevented for making any discrimination. On that basis, 16.4a, 16.4b have also been the part by inserting through the amendments in the constitution, and those are all declared as constitutional. So all these provisions which are the part after 16.4 and 4a, 4b, etc., they are leading towards the substantive equality, because this is for bringing the real equality, for bringing the equality in real or practical manner to those persons who were facing inequality because of many of the reasons. So Article 14, 15, and 16, which form the part of the scheme of the constitutional right to equality that guarantees equality, and to give effect to Article 14, you see Article 15.4 and 16.4. Those were earlier considered to be as an exception to Article 15.1 and 16.1. As I told you, that these articles have been inserted later on by the amendment to the constitution, and the Supreme Court in 1962 in Rangachari case. Yeah. In Rangachari case, that held that the 15.4 of the Constitution of India is an exception to Article 15.1. Because 15.1 is what? 15.1 is saying that there shall not be any discrimination. And 15.4 is making any the discrimination on the basis of that the persons who are belonging to a particular class, that is socially and educationally backward class of the citizens, or for the scheduled caste and the scheduled tribes, the law will be made by the state. State can make a special provision. But this view of the Rangachari judgment, that this is an exception, that was further, you see, accepted in few more cases by the Supreme Court, that not only the 15.4 is an exception to 15.1, but 16.4 is also an exception to Article 16.1. That it is implicit in the article that reservation cannot be made for all in the matters of the appointment. So this was there in the provision or in the judgment of the Supreme Court. You see, M.R. Balaji versus Mysore case also was there of 1963, which has followed the similar view as was followed in this Rangachari case. Tirloki Nath, Jammu and Kashmir also followed the same view. But when this provision was there, so you find that when the Supreme Court decided that 15.4 and 16.4 are the exceptions of 15.1 and 16.1, then the basic purpose of bringing the real equality could not be achieved. And that's why another case was decided by the Supreme Court by a larger bench, that was of a 7 judges bench, and that was State of Kerala versus N.M. Thomas. It was of 1976 judgment. And that introduced a change in the concept of equality. That is, it is going more towards the substantive equality. And it has held that Article 14, 15, and 16, they are the equality rights, and the scheme of the equality is just to sort the achieve the real equality. And hence the court in this case held that Article 15.4 and 16.4 are not the exceptions to Article 15.1 and 16.1 respectively, because These two articles 15.4 and 16.4 are meant to bring the real equality. They are meant to bring the practical equality, to achieve the equality and to protect the equality rights of the person concerned. So 7 judges judgment, and there were 5 different judgments were given by different judges. Chief Justice Ray, he has given his own argument and logic, but says that it is not an exception. Justice Matthews also gave his individual judgment, but again he said that this is not an exception, meaning thereby the Krishna Iyer, Fajal Ali, they all gave these their separate judgments, but all were came to a common conclusion that clause 4 of article 16 and clause 5 of article 4 of article 15, they are not the exception, but they are the explanation containing an exhaustive and exclusive provision regarding a reservation, which is one of the form of the classification. And this is something through which one can achieve the real equality. So you see, this judgment of N.M. Thomas was also upheld in a 9-judge bench of the Supreme Court in Indira Sahani case in 1992. With the majority, it has upheld this judgment that this is not the exception in a very, very emphatic manner. The equality has to be equality rights of the persons are need to be protected. Which is also known as the substantive equality. So Indira Sahani case has also followed the similar things as it has been given by the Supreme Court in N.M. Thomas case. Now, one of the point which was there decided by the Supreme Court in 2005, that is E.V. Chinnaiya case. And that is also important because the legislation which is said to be not amenable to the challenge on the ground of violation of Article 14, if the intention is to give effect to Article 15 and 16. So when the differentiation is not unreasonable or arbitrary, what has to be seen? Because this was the time when this Royappa judgment was also there, the reasonable classification doctrine were also there. And then how has the court has to go about? Then the court has followed the doctrine of reasonable classification. And then Priti Srivastava was also there. Then in the matters of the admissions, in the matters of the advancement of SC, STs, in the matters of the public employment, you may have a number of cases, right from Jagdish versus UP case, then T.P. Roshna case, P. Rajendran case, D.N. Chanchala case, Nishi Meghu case, in public employment, D.S. Nakara case, Brajanath Ganguly case, and many more cases. You'll find that where the court were of the opinion that the doctrine of reasonable classification, which is a way to bring the equal treatment or equal protection to the fundamental rights, and which says that Article 15.4 and 16.4 are not the exception to Article 15.1 and 16.1 respectively. These were all the judgments which were given by the Supreme Court in order to bring the equality in a real sense, as it is started right from S.R. Das case. Then further, if we go through what is the equality and what is the formal equality, what is the substantive equality, then we'll find that Article 15, Clause 3, 4, 5, 6, and 16, Clause 4, 4A, 4B, and 6, they have expanded the concept of equality by promising substantive equality, which permits the state to move away from the notion of the formal equality and to make the special provisions for securing the rights of the persons who are said to be marginalized, who are said to be the persons coming in the marginalized section or marginalized groups, so that the wrongs which have been suffered by these sections may not be repeated again. These provisions imply group identification as a method through which substantive equality can be achieved. So now, before moving further, it is important just to bring something or to focus more about formal equality and what is substantive equality. So from the previous discussion, you must be understanding now that the formal equality, which is a belief that for fairness, people must be consistently or equally treated all the times. Substantive equality, which goes beyond the basics of recognizing the equality of everyone, and it identifies the differences among the groups of the people with the long-term goal of the greater understanding, we can say. Formal equality is something which in which the law treats everyone equal and doesn't favor everyone. And substantive equality means the government must in practice do something, or the state action must be there so that it may make the people more equal in terms of the opportunity which they can achieve by these government action. So an open competitive exam, for example, if you see, may ensure formal equality, that the competition is advertised, and every student or every candidate who is having the minimum eligibility can apply for that. So that competitive exam may ensure the formal equality, where everyone has an equal opportunity to participate. However, the inequalities which are there available in the society and in the shape of the access to educational facilities, particularly during this pandemic time, you see digital divide is discussed very high. So if there are widespread inequalities which are prohibiting the candidates for accessing to educational facilities, which will be resulting in the deprivation of that open opportunity or the formal equality to appear in the or to participate in the competitive exam. So certain classes of the people who would be unable to effectively compete in such a system. So special provisions like reservation enable such disadvantaged class to overcome the barriers that they face in effectively coming or competing with the other persons or with the persons who are said to be advanced classes or the forward classes, and thus that can be ensured through the substantive equality. So some action, some constructive action is required in the basic things which is not required in the matter of formal equality, but that is required in the matter of the substantive equality. The formal approach to the equality stands in direct contrast to the substantive approach, which directs the attention to the question of historic and systematic disadvantages. We all know. The objective of the substantive equality is the elimination of all substantive inequalities of the disadvantaged or marginalized groups in the society. So formal equality and substantive equality are the two different forms of equality. They both are equality, but one is what the person is as it is, and the second is what it should be to bring the equality. So formal equality doesn't recognize any difference, whereas a substantive equality takes the grounds, various grounds which are there for the difference, those grounds as the individual identity of that person, like reasonable classification for those persons who are grouped together and those who are left out from that group, to recognize the different situations and circumstances, so that substantive equality gives opportunity of outcomes, that if something has been done by the state action has been taken on the basis of which those persons who are coming in from the marginalized group, disadvantaged group in the society, if they got the opportunity, then that opportunity will result into some equality. And that's how the substantive equality is also termed sometimes as the equality of outcomes and equality of results, which is used by Sandra Friedman, a very good writer on this substantive equality, has written many of the papers, and in her paper on the equality, substantive equality revisited, she has used these terms, the equality of outcomes and equality of results. So simply these terms have been made to make the state under action, so that the formal equality which applies to all the persons is not fit for those who are coming from different types of the diverse situations, from the diversity is there. So that's how you see the argument of Sandra Friedman on the substantive equality is what we find in the constitutional provisions under Article 15.3, 4, 5, 6 and 16, 4, 4A, 4B of the Constitution and 4, 6 and Article 16 clause 6 also. So this equality of results and equality of outcomes, that simply means that some affirmative action or some preferential treatment is to be given to the disadvantaged group, which is apparently you will find that it is breaching the equal treatment principle, but it is furthering the equality because it is resulting into the equality. It is coming into the equality because equality of opportunity is one of the aspect of that substantive equality. So reservation are the types of the affirmative action, whereas you see the proportion of seats are set aside for the previously disadvantaged persons. Reservation takes place in Parliament in India, the state legislatures, the assemblies, central and state civil services, public sectors. Various places are here in India where we find that these reservations are taking place, and that is something known as the substantive equality. So with a view to make this justice socio-economic and political, which is granted or in the preamble to the Constitution of India has made this special provisions in the equality clause so that everyone could be treated equally. And that's why, as an abundant caution, two phrases have been put in the Constitution under Article 14, equality before law and equal protection of the laws, while substantive equality is ensured through the equal protection of laws. That is the phrase which is giving way for the reasonable classification. That is the way which is giving the reservations, and this is the way wherefrom we can have the idea of affirmative action, and everything is being interpreted under that term of the equal protection of the laws as the 14th Amendment of the US Constitution. Now, coming to this substantive equality, which has been accepted and the words have been used by the Supreme Court in a recent past, some of the cases which have been decided, for example, in 2021, very recently, the Supreme Court has decided on 17th December, Ravikar Kumar Dhariwal versus Union of India. That was a case which was relating to the rights of the persons with disability, mental disability. There was discrimination on the basis of that, and the case was filed under the 2016 Act. So the court was of the opinion that the right to equality under the Constitution is having two facets: the formal equality and substantive equality. While formal equality means that every person, irrespective of their attributes, must be treated equally and must not be discriminated against, substantive equality is aimed at producing equality of outcomes, as used by Sandra Friedman also. The court in this case also discussed about the substantive equality and formal equality. So the court was also of the opinion that substantive equality is aimed at producing equality of outcomes through different modes of affirmative actions. That may be through reservation, that may be through positive discrimination, that may be by giving some extra opportunity to the person concerned. The case was related to giving some more opportunity to the persons who were mentally disabled in this particular case. So the principle of reasonable accommodation is one of the means of achieving this substantive equality. And substantive equality simply relates to the participation. It gives you the opportunity to participate in a thing in which you cannot participate because of various inequalities, various disadvantages. So this substantive equality confers upon you a right to participate, confers upon you a right to have the opportunity. This substantive equality is recognizing the individual's identity. It is not considering that A to Z, every person is equal. No, there cannot be, because of the various differences which is existing in the society. So substantive equality is something which is recognizing every person's individual identity, individual characteristics of the person, and then decides how to protect his or her right. So in case of the persons with disability, they may have different type of the disability. One may be a mental disability, other may be the physical disability, orthopedic disability, or there are 21 categories of the disability. So any types of the disability may be there. So a law which is meant for those persons who are physically disabled, orthopedically disabled, may not be fit for the persons who are mentally disabled. And that's why the individual identity has to be taken care while making any law or taking any action to bring the substantive equality. So this was the decision of the Supreme Court in this Ravindra Kumar Dhariwal in 2021. Then you see Justice Chandrachud also. He has delivered many of the judgments right from 2017 to 2020, 2021. You can find whether it be Sabrimala, the Shaira Banu case, the Nalsa case, and many more cases where this Babita Punia and Nitisha case. So I'll be discussing all these cases in which the concept of the substantive equality has been discussed by him. And Justice Chandrachud has divided this anti-discrimination law jurisprudence into two perspectives. And he, again, one is formal equality and the other is the substantive equality. And the jurisprudential origin for both these substantive and formal equality can be seen in Article 14 and 15, as he said that 14 is formal equality and 15 is the substantive equality. So it is not only the 15, but 16 is also substantive equality. A formal approach to equality is something which is premised on treating everyone like or same. And this approach says that any treatment that is differential between same individual or same group would constitute discrimination. This is a simple law. Whereas this substantive equality focuses on simply with the equal treatment of law. But it is also that what is the actual impact of that law, we can say, or actual outcome of that law. So substantive equality looks into the respective of different characteristics of the groups, and the differentiate that differentiates one group from the other group. On the basis of the gender, there may be differentiation. That's why we have Article 15(3) in the Constitution. There may be differentiation on the basis of the caste and class. We have the provision in Article 15, Clause 4 of the Constitution. And there may be differences on the basis of the economic matters. We have Article 15(6) and 16(6) in the Constitution. So the approach recognizes that treating unequals as equals only serves to widen the disparity between the two contesting categories. And that's why it should not be confined to a formal equality which may result into justice, but substantive equality is leading more towards justice to the person concerned instead of the informal equality. And 15(3), as he said, is a departure from the established principle of the sameness of the principles, because it is making special provisions for the women, it is making special provisions for the children. It is also allowing for correctional measures in the shape of the positive discrimination in favor of the children, in favor of the women. 15(4) in favor of the scheduled castes and scheduled tribes, as I told you. So basically, this equal protection of laws in Part 2, 15, 16, 17, and 18, these are all the provisions which are suggesting to the substantive equality. And further, you will find that many other cases which have been decided by the Supreme Court, B.K. Pavitra, as I was discussing with you also, that that is also a case where the substantive and equal authority, and this was also a judgment given by Justice Chandrachud. So you see that a reservation was under the Constitution was said to be an aspect of the substantive equality, which imposes a duty on the state to provide the groups who are disadvantaged in the different terms. And this B.K. Pavitra versus Union of India was also one of the cases where the court held that the equality to be truly effective in effective or substantive, then they must recognize the principle of the reservation and the existing equalities in the society. To overcome that, reservations are to be there, and they cannot be said to be the exception to the rule of equality of opportunity under Article 16 of the Constitution. And it is said that they are fulfilling, or they are effecting, or they are effectuating the substantive equality by accounting for the structural conditions into which the people are born, because we all know what were the situations, and on that basis these reservations are the part of the constitutional equality clause scheme also, which is reflecting on the affirmative action so as to give the remedy or to the persons who are belonging to a particular class, whether it's the other backward class, SC and STs also. So this is how you find that social justice concern, which is the preambular objective, which is there is an obligation on the state also under directive principles, and an extension of substantive equality is being meted out not only through the constitutional provisions, but also through the judgments of the Supreme Court in various cases. And you see this Reservation Act of 2018 of Karnataka, which was challenged in B.K. Pavitra case, that was discussed, that was held to be constitutional, and that was said to be a vision of the substantive equality and held valid. Then in Sabrimala case, regarding, you see, relating to that temple case, again, Justice Chandrachud noted that reading one of the paragraph of Dr. Ambedkar that says about the independence of the person concerned, that this is something related to the substantive equality, which is an struggle against the social emancipation, because you all know that the case related to the ban of the entry of the particular age group of the women in that particular temple. So how that can be grouped together, which is not a reasonable classification. And on that basis, the Supreme Court held that this is unconstitutional, and that one more feather was added to the substantive equality by Justice Chandrachud in this case, in the name of the transformative potential of substantive equality, that this is something which has to be there in our country. Then again, Nalsa case, you see, the court has found that Article 16 is the validating demand for substantive equality under Article 16(1). It's not an exception, which was already decided in N.M. Thomas case also. Then Navtej Singh Johar case also, you find that the reservation under the Constitution is an aspect of the substantive equality. So you see that whether the Supreme Court has considered this substantive equality, and it has been coming out of the provisions in the Constitution. Joseph Shrine case was also one of the important case in which you find the different postulates of the equality, which was again a judgment of Justice Chandrachud of the Supreme Court. And you find that in all these cases, Justice Chandrachud has discussed about the substantive equality, which is directed at eliminating of the individual or institutional or any systematic discrimination against the disadvantaged group, which is to effectively undermines the full and equal social, economic, political participation in the society, so that the society or the persons who are there, they may participate, they may get the opportunity to realize the equality in a substantive manner. So you see that any type of the subordination of the disadvantaged group persons, that was the focused area in all these judgments which have been delivered during this period of 17 to 20. Joseph Shrine, Navdeep Singh Johar, Nalsa, and many other cases. Then Shaira Bano case also, you see, that was decided on that similar basis, that which was said to be, violating or performing that the discrimination of the law was found to be there. It was arbitrary law, and that was to be declared as unconstitutional, which is again an aspect of the substantive equality. So finally, if I would see that some more cases which have been discussed and decided by the Supreme Court on substantive equality and on formal equality are relating to the women cases, because you find that the Supreme Court has struck down the evaluation criteria of the Indian Army, that it is irrational and arbitrary, because it is not favoring the women army officers in attaining their permanent commission. And it was in 2020 February that the Supreme Court has come out with a judgment in Secretary Ministry of Defense versus Babita Punia case. It was 2020 judgment, which ordered that the women in the army, they will be granting the permanent commission in the territorial army. But when the judgment was given, that was not being executed. So once again, almost a year later, one more case was brought before the Supreme Court, Lieutenant Colonel Nitisha versus Union of India, which was questioning the modalities which were followed for assessing them, that they have been granted the permanent commission. The Supreme Court has given the decision, but that was not executed. So how the government is making the modalities to bring them in the permanent commission? So according to this particular case, if you find that in Nitisha case, the division bench of the Supreme Court, once again, Justice Chandrachud was there with Justice M.R. Shah. So they favored the petition of Lieutenant Colonel Nitisha, and the court in this case has minimized the scope of criticism with regards to the commitment to ensure for the substantive equality. It held that the court must not only quash the discriminatory practices and compensate for any harm that was caused, but also to structure adequate remedies that facilitate the social redistribution by providing the positive entitlements. And this is the case where you see that this doctrine of indirect discrimination was also introduced by the Supreme Court in this very case, Nitisha case. Though this doctrine of indirect discrimination that was evolved in US Supreme Court, it was somewhere in 1971 in Greek's case. But in India, it is at a very, very initial stage, and this recognition of indirect discrimination in a policy or in a law, that also ensures substantive equality for disadvantaged section. Discrimination can be a consequence not just because of the intention is to discriminate, but unconsciously also biases can be there. So this is something which is related to the indirect discrimination. This occurs when there is an effect of unfair treatment without any intent. Intention may not be there, but whatever is the result, that is unfair, that is illegal, that is unequal, that may be considered to be indirect discrimination. So this Nitisha case was an example for that, and the right to substantive equality would not be satisfied by a concept of indirect discrimination, as I think, which permits the justification without giving more focus on the other criteria which can be better, like reasonable classification or something like that. So we find that this direct doctrine of indirect discrimination now is coming up as an extension of the substantive equality also, because the court wants to give the end result, because substantive equality is said to be something, the equality of result, equality of outcome. So the courts have tried to give the end result which is said to be equal, without going into the intention, without going into the unfair treatment or the effect of that treatment, whether it is good or bad. But if it is resulting into discrimination, then the court would come up for giving the relief to the person concerned in the way of indirect discrimination. And related to that, one more case decided on 20th January 2022, Neil Aurelio Nuns versus Union of India. First aspect, that was N.M. Thomas, repeated once again. 15.4 and 15.5 are not the exception of 15.1. Which itself sets out the principle of substantive equality, we all see. So the similar judgment was also, you will find in the concurring judgment of Justice P.N. Bhagwati in Minerva Mills case, because there are many of the cases which have discussed on all these issues. It's not possible to discuss all these cases in detail, but the focus is only on the formal equality and on the substantive equality, which speaks out of the equality clause, which finds place in the Constitution of India. And it speaks of the substantive equality, the concept of real equality in the shape of the equal protection of the laws in the country. And this is just in order to give the equal treatment to all the person concerned. In 2021, one more case was decided in November 2021, state of Tamil Nadu versus National South Indian River. That was relating to the Agriculturalist Association, where the small and marginal farmers belonging to the economically weaker section of the society, and therefore the waiver of loan scheme in favor of those group who are belonging to that weaker section of the agriculturists. That was said to be not against the equality, but it is introducing something like bringing substantive equality in the society by using the affirmative action in those persons. So classification has been made between the farmers or the agriculturists who are becoming under one category or other category, weaker in weaker section, and otherwise socially and economically weaker section. And that's how you see this National South Indian River Interlinking Agriculturalist Association case of 2021. That also again extended this doctrine of substantive equality by making the classification reasonable and to bringing the protection of the equality rights to those persons who, or those farmers who are belonging to the economically weaker section in the society. And again, Justice Chandrachud with the Justice Bopanna in this case have discussed this substantive equality, that Article 14 is formal equality, and Article 14 Part 2 and 15 and onwards, they are the substantive equality. Then if we find that what is going on in today's scenario, everybody must be aware about this hijab controversy, you can say, or discussion, you say. So there is, evolving a different type of the discrimination also, which we can say whether it is leading toward the formal equality or it is leading towards the substantive equality, or it is an extension of the indirect discrimination, or yes, in yesterday's paper of Indian Express, as I was going through one of the article written by one of the advocate of the Supreme Court, Tulasi K. Raj, she writes it as the hostile discrimination even. So any discrimination which is based on any of these grounds may be also named as the intersectional discriminations, because what we find that in Navtej Singh Jauhar case, the Supreme Court through Justice Chandrachud highlighted the inadequacies of the two-stage test that has been given some overemphasis on the objective of the law instead of its effect. So when the effect is to be seen, then we have to go for the substantive equality, and it was observed that And this was a case, Navtej Singh Johar, which is related to this LGBT right case, and the court held that the essential content of any anti-discrimination provision which are there, which are appreciating some intersectional discrimination, which is based on their different identities or different characteristics, that has to be upheld. So the present hijab controversy, that is, I'm not going into the detail relating to the freedom of religion, right to freedom of religion, but looking that from the lens of the intersectional discrimination as held in the Navtej Singh Johar case. So as intersectional identities of being a woman and of being a Muslim also. So any discrimination on this ground only is a that is prohibited under the equality clause on the basis of sex, on the basis of religion both, because these two you will find in Article 15(1) and at 16(2) also, that there shall not be any discrimination, or the state shall not prohibit anyone on the ground of sex and religion. And here you see that ban on the clothes as violative of public order is indirect discrimination. That as I told you, is written by the Supreme Court lawyer in yesterday's Indian Express paper. So there she argues that indirect discrimination occurs when an action is neutral on its face. Because as I told you, what in Greek's US Supreme Court said about that, it is something where the intention is not there for the unfair treatment, but the treatment is unfair in result. So that is said to be indirect discrimination, which we find in Nitisha case also, that the decision has been given by the Supreme Court in Babita Punia, but that was not executed. And that's why for that to make out the modalities as to what should be there for granting the permanent commission in the army, the court has accepted this doctrine of indirect discrimination. So here, this indirect discrimination occurs with this order of this ban order on the clothes of the Muslim women, for that hijab related order. So when an action that which is neutral in its face, but disproportionately impacts a protected group. And I also see that what the Supreme Court in Nalsa case said about the choice of dresses. Though that was discussed as an extension of the fundamental right under Article 19(1)(a), that freedom of expression to wear any dress of the choice. Of course, that should not come under any of the reasonable restriction under Article 19(2). But otherwise, what type of the dress one can carry, that is his or her freedom of expression under Article 19(1)(a) is a clear decision in Nalsa case. So in that respect also, what type of this indirect discrimination is there, or as Tulasi says that this is a hostile discrimination, we have to see whether it is violating the right to equality first and then freedom of religion, or it is a case of freedom of religion first, then right to equality. So coming to the end, I would say that there are many issues. There are many challenges also regarding equality and discrimination, positive, direct, hostile, whatever may be there. But the need really is to make these affirmative action programs more effective. Instead of confining them to reservation alone, other programs should be followed. The programs for special training and for the development of skills and measures to encourage the previously disadvantaged to pursue excellence, that should be taken up, because a reservation or quotas can never be the answer. Sometimes this cause more resentment amongst the non-beneficiary groups also. We have seen right from Mandal time that what type of the resentment was there. So affirmative action is now over 70 years old, and equality is not achieved, we all know, because if it would have been achieved, then there would not be any extension of the affirmative action provisions or reservation provisions. The government that implement affirmative action, that must have a reasonable goals within the set time frames, so that whatever is desired by these affirmative actions, by this substantive equality, may be achieved by eliminating all types of the discrimination. So the formula which has been started in 1950, that is the reservation, positive action, whatever it is, if it is not being fruitful till 70 years have lapsed from that time, then whether we should not think of some other formula, whether we should not think of some other types of the trainings, whether we should not think of some other types of the development of skills, instead of doling out whatever we are being given. Because every time you can see in the newspapers that the students and the others, they are claiming, they are demanding these things. So who are the beneficiaries for this substantive equality? And I would like to end with the quote which has been written by H.M. Seervai in his book, that is the 4th edition of the Silver Jubilee edition, volume 1. And he writes that, which is very near to all this substantive equality. I would like to read that paragraph for you all, that in past injustice done to members of SCs and STs because of the accident of their birth calls for condemnation. So does justice, so does injustice done to members of advanced classes because of the accident of their birth. It may be that members of advanced classes may have to bear for a time at best as they can, and the injustice done to them by reverse discrimination, if a long-standing historical wrong, has to be righted. But 40 years have gone, because this is a book which was the edition of 1991. So at that time it was 40 years. So he writes that, but 40 years have gone by since our constitution came into force, and every year that passes increases the individual's sense of injustice and injury. It is submitted that judges who have to balance the claim of all the parties affected by an action under 16(4) ought to reflect that if the injustices of the past are to be strongly denounced now, then the future will denounce quite as strongly the injustices suffered by the members of advanced classes since 1950. So substantive equality should be such which may treat everyone, valuing their individual identities, not to be based on any inequality which is there from time immemorial, because 70 years is a very, very long period. And what we find in the substantive equality, to some extent, formal equality is now not being seen in its real shape. With these words, I will stop here. Thanks once again that I also refreshed many things because of this lecture, because this was going to be very, very wide, but I have to confine within time also. Many of the cases which I could discuss at detail, I have not discussed because this